Sam is in Bedford. Sam, good evening.
Hi, Sam. Sorry. Thank you very much for taking my call. Sorry, Daniel. A friend of mine has an employment contract which is about to come to an end. It's a 2-year fixed-term contract. They've been on...
Sorry, did you say 6-year contract, Sam?
Sorry, a fixed-term contract.
Fixed-term contract.
So that's been a 2-year fixed-term contract, and it's about to come to an end.
Yeah.
They've been on sick leave due to disability for the past 8 months. They've been in regular contact with occupational health, and the plan is to start work in September with the same employer, but with a different branch. But their initial employment contract says that their employment rights should continue if they switch employer. However,
you just said it's the same employer, but then you just said they're switching employer. Just clarify.
Same employer,
different branch. Okay.
Sorry. Okay. But at the moment, it looks like there's going to be around a month gap between the end of their 2-year fixed-term contract and the start of their next contract. And our question is, basically, does that matter? Does that affect their employment rights if they're still on sick leave during that month break?
Okay,
or
so
is it important to try?
Is your friend fit to go back to work? Because you said that he'd been off sick for 6 months.
Yes, so he'll be fit to go back to work in September.
Fine. The reason they're doing this 1-month break is to break continuity of employment, because a month break will reset the amount of employment that they have from 2 years to 0, with one caveat which I'll come to in a moment. And if continuity of employment is reset from 2 years to 0, they lose the right to claim unfair dismissal, and they have to start waiting for another 2 years before they can claim unfair dismissal from this newer job. So it's a very simple tactic by the employer to stop them getting employment rights for another 2 years. Normally, employment rights kick in at 2 years. However, luckily, you phoned the LBC Legal Hour because there's a relatively little-known exception to that rule that a month's break will reset employment back to 0. If the reason for the month's break, when there's no contract of employment in place, is absence, and the cessation of work is temporary because of absence, it doesn't reset the clock. It's an exception that lots of employers don't know about, which means that your friend will continue to employ continuity, meaning your friend will still be able to claim unfair dismissal and she'll have employment rights when she goes back to work in September.
Okay, is this Section 212 of the Employment Rights Act?
It's Section 212, subsection 3B from memory.
Okay, I was looking at 3A, which is being capable of working.
That's 3A, thank you.
Injury?
Thank you, yes.
Okay, perfect. Okay, and is there
so you knew the answer, you had no reason to call me, Sam?
Oh, I was just double-checking. The person was covered. I didn't want to say it was still going to be okay if it wasn't.
Okay. But no,
So
absolutely clear-cut, solid grounds, they're going to be fine. They'll keep their employment rights.
Perfect. Thanks so much for your help.
Thank you very much.